This channel does not promote any violent, harmful, or illegal activities. All content provided by this channel is meant for an educational purpose only.
Yes, Mr. Mitru.
May it please the Lordship.
On the last occasion, you stopped at the judgment of the Honorable Supreme Court, where the Madrasa Act was practically revalidated after setting aside the order of the Honorable Single Bench and Honorable Division Bench of this court. There is stop.
Yes. No, that is. May I now humbly submit, my lord, that question before Lordship whether selection process as adopted by the Commission should be nullified or should be set aside. They say it will be nullified or set aside on the ground that our division bench is supposed to pass an order restraining holding of second written test. That's what I understood, my lord, to be. Now, is the question, therefore, I deal with that question first, today, and then I would like to finish today immediately. Is there any dictum of our High Court at the single bench or the division bench that regarding the procedure to be adopted by the Commission upon detection of mistake? My humble submission, my lord, there is no dictum to that effect of the Supreme, of our High Court. Thus, you have seen the first order, single judge's order about the question of nullity and all that, those things, let us forget for the time being. And the division bench simply modified the order by extending time because the writ petition also consented.
Writ petitioner
consented to the modification by extension of time. Let's notice that. Can you see the order?
We first filed our composite.
Page. What we get it? Also have a copy. Order is that is dated, my lord, 4th February 2020. My lord, got the order, my lord?
Yes, sir, I got it. Give me a second.
First is single bench.
Give me a second, Mr. Mitru.
Okay.
Yes, sir.
The second paragraph also, in view of the subsequent stand, last but one paragraph taken by the appellant, do not delve to go deep into the legality and infirmity of the impugned order.
4th February.
4th February.
Which paragraph you are referring, sir?
The second page.
Second.
Last but one paragraph. Last but one paragraph. Last but one paragraph.
Very good, sir.
In impugned modified to extent. Whether it's good but indifferent, the question is not gone into even by the court. In direction is, in terms of the order, do within 6 months. Apply the order within 6 months. Within 6 months, the modification of order. Without any opposition from the parties.
Hey, Kulanbu.
Yeah.
এটা দিন তো আমাদের রেখে Yes.
Now, the three directions have to be complied. Very strictly order says. last paragraph, modified to the extent that time is only extended. Directed to last line, impugned order is modified to the extent that the appellant is directed to that extent. Appellant directed to complete the exercise strictly in terms of the direction passed by the impugned order within 6 months from date. And also in view of the above, appeal and the application disposed of. Appeals are disposed of. Their appeal is disposed of by this order. There is no appeal then pending. Appeal and application are disposed of. No orders to cause. Then, with my kind permission, also has been order. What was the direction given by the single bench, which is to be complied with within 6 months? Also, in that manner, may I only take 1 minute for your lordship time, see that order of honorable single judge, and see what directions were given by the honorable single judge to the upon the board. Please, minute only. This order is dated
23rd July 2018.
23rd July 2018.
Yes, sir.
Order of Justice Pratik Prakash Banerjee.
Yes, sir.
First page is the fact. Second page, the page 2, accordingly. Kindly see what are the directions given which are to be complied with strictly by the board within a time limit. Accordingly, the present petition is disposed of. After recording that, it did appear in the examination first level and on second March and on the date is corrected, May 29 or not March 20, submitted by both Learned Advocate and Mr. Dewan, Learned Counsel for the Commission, and by directing the response 2 and 3, I'm not going to go to defunct and all that now. The forthwith intimate, first direction, intimate to writ petitioner the result of the evaluation of answer scripts. Second direction, if he is qualified, then prepare the panel in the terms of Rule 80. If he is qualified, then only. Second direction. And if he is eligible as qualified candidate in terms of the such register candidates, then the said respondent shall issue invitation letter to him for personality test. Similarly said, evaluate his answer script, and if he is qualified, then prepare the panel in terms of Rule 80. If he is not qualified, then need not prepare. Need not prepare. If he is not qualified, then in such term, and the respondent shall issue invitation letter to him for the personality test in terms of Rule 90. You see, the 3 directions given below. None of the directions says that don't hold any second test or how to evaluate, how not to evaluate. And it's 3 directions conditional directions.
That question didn't arouse that material time.
That's right. My lord, absolutely correct. If I respect, my lord.
And
correct.
then, Mr. Mitra, what I asked the Mr. Dhar also, I am asking, can these actions be complied? Can these actions be complied with by the commission without publication of the entire result? I believe no.
No, this is not clear to me, my lord. Direction that if he is qualified,
forthwith intimate to the writ petitioner the result of evaluation of the answer scripts.
To the communicate the writ petitioner.
No, Mr. Mitra, try what
sorry.
I'm sorry.
Very sorry.
Probably I'm not.
I'm sorry.
Probably I could not explain you properly. What I intend to say, sir, by directing the respondent number 2 and 3. Sir, kindly come to that line. By directing the respondent number 2 and 3 to forthwith intimate to the writ petitioner. That is Malakar. Am I correct, sir? The result of the evaluation of answer scripts.
Not entire. Forthwith intimate.
Sir, that I intend to know from you. Can a single person be taken out from the entire examining list and only his result can be declared, or this action can be done only when commission publishes the entire result? Sir, what does it mean actually?
As my lord said with respect, and very right, he said, if I may use the expression.
Sir, had it been,
That,
it is
that
a,
is- that
sir,
is
Mr. Mitra,
clear.
it is a competitive examination.
Yes.
Suppose
Yeah.
me and my staff appeared in a Madhyamik examination, higher secondary examination, graduation examination, say class 8 examination. It is possible to evaluate my answers. How many marks I have got in mathematics, how much marks I have got in bioscience, biology, how much I got in English, Bengali, that can be done. But it is a competitive question, examination. Everybody is competing with each other. Therefore, their process of elimination is always there. So, if this honorable single bench, in the event single bench directed the commission to intimate the repetition of the result of the evaluation of answer scripts, does it not mean that you have to publish the entire result?
What Madhav is saying is completely supported by the second direction. Second, if he is qualified, then this, whether is qualified or not, that can be found out.
On publication of the entire result.
That's what Madhav is saying. It's a completely supported.
Absolutely, sir. That I intend to do. So, practically, the Honorable Coordinate Bench directed for publication of the result.
No, result not. Panel paper. If he is qualified, then prepare the panel. If upon evaluation answer scripts, if it is found that repetition is not qualified,
Sir, how a panel can be prepared without determining who are successful and who have achieved the cut-off marks or not?
Yes.
For a single person, a panel cannot be done, sir.
That's the board's affidavit also. 297 vacancies. First, as my dad said,
Elimination.
first 297 will be eligible. Now, can you see how the election process took place? Board's affidavit. Board says on the evaluation of the examiner's written answer script of Mr. Malakar, he was not qualified. Can you see me that board's affidavit to that extent?
So, sir, how it is relevant for the purpose of present lease? That I kindly explain. What I intend to say, sir, Honorable Coordinate Bench, when passed the order dated 23rd July 2018, does it not mean that for publication of the entire result, so as to prepare a panel, will be eligible for appearing in the Viva Voce? That I intend to know what would be your submission.
My submission that on that date, the single bench was of the impression. Now see the method. Why the result was not disclosed? First paragraph of the order. What representation?
Mr. Mitra, I am sorry. You have to answer me on that point on. What I intend to know from you, sir, very specifically.
Yes.
From the order passed by the Honorable Coordinate Bench in Malakar space, does it not indicate that the Commission has to publish the entire result so as to comply with the order of the Honorable Single Bench? Or if the answer is yes, all right. If the answer is no, what would be your explanation, sir? That I intend to know. Thereafter, I will go to any other point.
Humble submission, Milord, that implication cannot be inferred from this order. He has not clearly said and shall support Milord my humble submission.
So no implication of publication of entire result can be inferred.
No direction for publication. Number one reason.
Very good. No direction.
Reason
It is your submission.
Reason number one, that direction to prepare the panel is conditional upon Mr. Malakar being qualified in the written case.
Sir, is it not a fallacy?
Order may be wrong. That's right. That bless the Lordship.
How can it
The
be,
order
sir?
is wrong. Maybe order is wrong. That's the order was a nullity anyway.
If the order is wrong, the Commission has not challenged it.
Therefore, the Commission has not done
It has not been challenged.
Yes, Commission has not challenged. Commission accepted this order. That's
Absolutely.
Commissioner view. a commissioner acceptance will not make an order, a correct order, if it is otherwise not correct. That will not, they are not the judge. And if you have a nullity, nullity cannot be accepted. I'm leaving aside that question. When the court gives a direction that if Mr. Malakar is not qualified in the written test, then don't have to prepare the panel. You have prepared panel only if Mr. Malakar is qualified, then to prepare the panel. I cannot say, below, that this direction was given to prepare the panel and to declare the result of the panel. It is conditional, not absolute. This passage, Miller, has not been perhaps highlighted to your lordship. The direction to prepare panel, which is the stepping stone for preparing the results, is conditional. Is a conditional order, is a contingent order. Then prepare panel in terms of Rule 18. I am handicapped. I should not pass any order on the correctness of this order because Division has directed Commission to comply with this order. Under this order, my lord, if Mr. Malakar was not found to be qualified in the written scripts, then Commission was not to prepare the panel. Non-application mind all over. Non-application mind all over. Similar, division, under the division, if that Mr. Malakar is not qualified in written test, then in terms of Rule 18, panel need not be prepared by the board, by the commission. If, and check, there is another if. That it is because of, if I may say, court attention not being drawn, that to the fact that there are other candidates other than Malakar, and there is a huge in number. Court attention was not drawn to the fact that Malakar was not the only candidate, and there are more than 1 lakh candidates involved.
Come to the second paragraph of the first page of that order.
That's
Come to this first page
of this order. Yes,
yes, sir.
That's
Second
what I'm
paragraph.
about to point out to you, Lord. Tell me, Lord.
In the kindly see the first last line of the first paragraph. The sentence starts with in the report.
That Mr. Dewan, Nalnet Council, that put
that little below
appearing with Mr.
in the report.
Yes.
Kindly read, sir.
Yes. In the report, the reason for not publishing the result of written test and given as follows.
Sir, kindly place them.
Yes, this is the change. That's
Then,
the blessing, below.
The result
What
of the
was
said
the
written
impression?
examination is yet to be published.
That it is yet to be published as the instruction Southwest Madrasa Commission.
So,
Madrasa Commission.
the Malakars, the read petitioners, that is Somen Malakar's main grievance was examination was taken on such and such day.
Yes.
Result was not published.
Because
From that perspective, these orders have been passed.
because the matter as referred.
Still, you say that without publication of the result, preparation of panel is possible.
And that's absolutely, that is how the court mind was moving. And my lord, absolutely correct. We utmost respect, because the ratio of the order of Justice Putik Prakash is that board is not subservient to the government, state government. So, my lord, result of the written examination yet to be published as instruction has been sought by the West Bengal Madrasa. Instruction on what aspect? Was it on the aspect that mistake detected and you want to hold a second examination now? That must be instruction on what aspect? that I have held written examination of 24,000 candidates, but now we find that another 70,000 candidates are eligible, whether they should hold second examination. I mean, written examination for them also. What is the instruction sought for? That may be the instruction they have sought for.
No, that was never surfaced.
Never submitted, but who can submit
That was
this?
never surfaced.
Therefore, Lordship we cannot infer.
During the pendency of the litigation before the Honorable Single Bench and Honorable Division Bench, that reason was never surfaced.
That is the question.
What instruction they have
what
sought?
was the instruction? Nobody knows. But law does not float in the air. Facts of the first service are submitted. So it is not open for us and for anybody to guess upon the nature of instruction which the commission has sought for the state government. State government, Lordship did not ask a question to the state government. Commission. Commission has not said so. Pertinent facts depend to be discovered. And my name is Lordship and saying without, it is a pertinent fact to be known, as now Lordship seen that. But not so many arguments have been made. What was the nature of instruction that was sought for? To that, Justice Pratik Prakash said that board as a commission is not subservient to state government. That's the thing. Yes, but in second thought. Now, my lord, I can guess, if I may say reasonably guess, that upon finding this anomaly, the mistake upon being discovered, the commission has sought for state government's instructions regarding procedure to be adopted. Now, what is the other guess possible? All speculation. On speculation, my lord, will the employment and live blood under Article 20 of the Constitution of 297 candidates be cancelled? On speculative arguments. This argument, my lord, I'm obsessed on this it is now coming on surface. It has dawned in this proceeding for the first time after 5 days hearing. Now, let's come to the question, my lord, therefore. Is there any legitimate, irresistible grounds to come to the inference that the court, in that conditional order, has directed then that the result will be published for all and sundry, even if it is found that Malakar is not successful in written examination, that is acting contrary to the order of the court. Look, if I now place the order of revision bench also, there is no specific order of either single bench or revision bench, single bench, saying that don't hold examination, written test examination for those left out candidates who have now have been found to be successful. This is a very serious matter. It has to be specific direction of the court. Single bench order and division bench order, those are two final orders. Appeal disposed of by the second order of 4th February 2002. Sorry, 2020 or 2020. Appeal disposed of finally. This is no longer pending in the court. Other orders are the nature of interlocutory orders, as my daughter, please stop, sir. Those are not final orders. Those are not substantive order. on the merits of the case.
Then, Mr. Mittu, what have you got to say with regard to the finding of the Honorable Division Bench in paragraph number 13, 14 and 15 in 13 say of the order dated 13/6/2024?
I just coming to that. Those are applications for extension of time.
But what are the grounds for extension?
Very good. Let us see the grounds taken. Now, whether court will consider what was the risk in judicata in those extension applications. Grounds, court will see that the grounds forwarded for or placed for extension are they valid grounds or not. For valid grounds for extension, whether the grounds are legal or illegal, that is not the question. Kindly bear this distinction in mind. Court is extending the court will only consider the grounds given, false, right, or wrong. Court, whether there are grounds for extension. Court is not going to the merits of those grounds. And that is not the court's job while passing an extension of time. And court has nowhere held that grounds are illegal. I'll come into that. Now, before that, may I humbly submit a judgment has been cited by Mr. Thor regarding the effect of interlocutory orders.
Effect of?
Interlocutory orders, the Supreme Court judgment. But before that, my lord, before we go to the Delhi, may I ask your lordship respectfully to come to Calcutta and see our division bench judgment. That is more on the point. That is reported in AIR 1988 Calcutta, page 25. There are two division bench judgments at there.
Paragraph, sir?
I give right now. Give me the paragraph. Yes.
Petitioner in WPA 845 of 2025.
Yes.
Petitioner in WPA
I'm not give me the
845 of 2025.
Page 25. Yes, not kindly see that a substantial part of the
give me a second.
Relevant.
Yes, sir. Which portion you want to like?
Paragraph 6 first and I'll see the judgment.
Paragraph 6.
6 and see the judgment. Then why the question? On the merits also, we are satisfied that trial judge was justified in making the impugned order of injunction. The defendant has not yet filed his show cause against that plaintiff application for injunction. And therefore, at this stage, all the statements made in the application will have to be accepted through modo ne form. You may not agree with this observation, but says so. And when so taken, allegation is, in our view, make out a case for ad interim injunction. As and when that show cause would be filed by the defendant and the plaintiff application for injunction be taken up for final hearing, the learned judge would obviously consider such show cause and all such materials as could then be available to him. Then, in case of injunction, where the case of injunction suit is made up, then marginally marked portion. This is marginally marked. As is well known, findings arrived at in dealing with application for temporary injunction, pending disposal of suit, even if they relate to any material question involved in the suit, cannot take the place of finding in the final decision of the suit. And if any citation is necessary for such an well-established proposition, reference may be made the observation made by Justice Dasgupta, Kashi Dasgupta, Chief Justice. In the division bench judgment, that judgment I have also got, 15 CWL. For sure, right. Therefore, finding, if any, made by us in disposing of this appeal against the impugned order of ex parte injunction cannot in any way take the place of finding to be arrived at in disposing of the application for temporary injunction now pending before the under trial judge. So, that's whatever the judgment, that is not relevant when Lordship is now giving the final judgment.
Mr. Mitra, if I say in other words, if you please permit me, of course.
Yes, no.
Does it not say that all interlocutory orders passed in a proceeding merged with the final judgment?
Merged in the
final judgment. Does it not say? Merged. All interlocutory orders passed in a suit merged with the final judgment.
With respect, the doctrine of merger is confined to a final order passed by a single bench with the final order passed by the appellate court.
No, sir. I'm not on that.
That is the merger. No other.
No. What I'm on.
Final interim order cannot merge with the final order passed in a court.
Which one will prevail? Ultimately, the final judgment will prevail.
Yes. Final.
Now, in this case, sir,
interim
order was passed prior to disposal of the suit.
Yes.
Prior to disposal of the suit.
Yes, Mr.
I believe you will concur with me.
Yes.
Now, sir, try to understand. So, what the Honorable Division Bench said, that the finding at the interlocutory stage, a court should not be persuaded with that finding at the final stage.
Yes.
Am I correct?
Absolutely, sir.
Situation in the instant
is worse.
Similar.
In a case, worse.
Similar.
Not because similar. It is from my point of view much worse.
It is post disposal of the appeal.
Correct. Then what's the situation worse?
It was pre-disposal of the suit or proceeding.
Correct.
And it was post-disposal of the appeal.
Right. Therefore, this situation is worse. In this case, finally disposed of. The main lease disposed of by final order.
Yes, sir.
Whatever directions have been given in the main lease has been concluded. Main lease. By interim order, court cannot change that or anything. That's it. Worst case. Our case is worse. As my lord say, interim order may merge, etc. Those things. In this case, order has been given finally, 3 directions have been given. Question is, court can only extend the time for compliance with that direction. That's nothing. That's all and nothing more. Court has no jurisdiction to give a meaning to that order. Court will see whether ground exists for extent of time, 6 months or 1 month, whatever it may be. That's why is the court jurisdiction in a disposal of matter to imply to or interpret or say, add something to the order passed by the court while in session of the matter? Court is not in session of the final order now. Court is not session of the petition number such and such. It is not kindly bear in mind, not most respect to submit, that it is for extension of time fixed by the court. And court will only see that the ground exists for extension of time for complying with the direction given by the single bench. 3 directions given to single bench. That's all and nothing more. Court has no jurisdiction to go otherwise. That is the first. There is no question of any obiter dicta. There is no dicta at all. Unless obiter. Court had no jurisdiction to give any directions which are not given by the court while disposing of the lease. Now, if I may now come to that order and I respect a bit. Our court has not done so, has not given any additional direction or anything. That don't do this or don't do that. My lord was referring to the judgment order of 13 June. Can you see the judgment, my lord? Whether that in the judgment we can at all imply certain dicta. Please, my lord, come to paragraph 4. And see, my lord.
Yes, sir.
Paragraph 4. And similar serious omission there, here. Very serious omission. Court cannot modify the, extending court cannot modify the order of the court. Cannot modify. Lordship, I think Lordship will accept this proposition. Court, while extending a time fixed by court, but complying with the order passed in an appeal, cannot modify the order. Nobody applies for modification of the order. Please see below paragraph 4 now. What will the others say argue that will amount to modification of the order.
Order 41 does not permit so.
Order?
Order 41 does not permit so.
Order 41, extending time cannot. Is a court extending the time.
In an appeal,
See?
in an appeal, Order 41 does not permit so.
No, appeal 41 is no application for extension of time when appeal is disposed of. 41 applies regarding disposal of appeal. Appeal disposed of, we have shown you, Lordship. Appeal finally disposed of. Order 41 does not apply to the appeal disposed of. It comes the question of execution now of the order. That will order 21 execution.
Then are you talking about that after disposal of the appeal,
Yes.
the division bench has become functions officio?
Will not?
The division bench has become functions officio.
Division means over the main matter has become function of issue. Because the court has fixed the time, only that court can extend the time, that is the time can be extended. Extension of time. Fixed by that court, that's why this court can extend. But I need not go use that strong expression, function of issue, anything. I don't intend to, but all the humbly submitting without a court after a lease has been disposed of, cannot modify the order passed. It can only extend the time fixed. Order 41 Rule 33 may not applies to in a pending appeal. Court can pass such order as the single bench could have passed.
So the power to pass any degree and make any order which ought to have been passed.
Order 41 Rule that ought to have been passed. That is, in an appeal court while considering the order of single judge. Order 41 Rule.
So when the appellate court entertains an application for extension of time,
Yes.
after disposal of the appeal, the division bench, then under which provision this division bench?
Part of court, under inherent part of court.
Under inherent power.
Time once fixed.
So inherent power empowers the court to modify the order.
No, cannot modify the order. Only extend the time for compliance with the order.
No, sir. We have to take on one stand.
Hmm.
Either we have to take that after disposal of the appeal, the division bench has become functions officio. If that be so, the others orders need not be looked at. If that is accepted.
Good.
But if we accept that no, after passing of the division measure, after finally dispose of the division bench by the appeal, the division bench has not become functions officio, which becomes evident from the subsequent actions of the division bench while entertaining the subsequent applications. Then, sir, I believe it would be your submission that Order 41, Rule 33 has got no application. The court has exercised its inherent power. So, if the inherent power is that, if the inherent power of the court is concerned, even under Section 151 of the Code of Civil Procedure, there is large.
never large. That is not as good. Power court has fixed the time for doing something. That court can extend the time. For doing that, that's something. At the time of extension of time, court cannot say, I extend time for
Probably,
doing.
Mr. Mitra, I could not, I failed to make you understand, sir. So try to visualize the chronology of events.
Yes.
The Honorable Single Bench passed an order, rightly or wrongly, whatever may be. Appeal was preferred before the division bench. So try to understand what I intend to say. At the time of hearing of the appeal, the appellant commission had practically chosen not to press the appeal basically. Rather, had foregone the grounds of the appeal. Yes. Their prayer was before the division bench to extend the time because of their infrastructural such blah blah blah. Now, with that finding, division bench disposed of the appeal, sir. Disposed of the appeal, extending some time to the commission to strictly comply with the order of the single bench. That you have interpreted, I have noted, sir. Now, sir, what I intend to say, when the division bench entertains subsequent interlocutory applications being separable CAN numbers for extension of further interim order, what I intend to say, can it be not called that it is an extension of the time on the basis of the finding of the main appeal. On the basis of the finding of the main appeal.
Not basis of finding appeal.
Because in the main appeal, the only order was passed by the appellate court for extension of time. In the subsequent interlocutory application, prayers were made for further extension of time on some grounds or other. So, sir, try to visualize the chronology of events and make your submission.
Single bench has directed completion of the directions within 14 days. The division bench said 14 days compliance is extended to modified to 6 months. That's all. The directions that were given by the single bench are not modified by the division bench. While disposing of it. Clear? Am I clear? Division bench, on the other hand, said comply with the direction given by the single bench and nothing more. Time is extended. Now, my lord, I humbly suggest to submit, my lord, a court which has fixed a time for doing something may, on sufficient ground, extend the time for doing that, even after expiry of that time, to do that. That is the only thing. While extending a time for doing something, court cannot. Court has no duty to modify what is to be done. What has to be done is fixed by the final order of the division bench and single bench. It will be chaos in the judicial discipline. Order is passed by the appeal court saying that do ABC. Then the appeal court can dissolve, time expires, another division bench takes up the matter and he'll say, no, do ABC and D also. Is it logical to think on that line? Can our division bench be attributed with that intention? And the second, another ground is there.
On that ground, Mr. Dhora has argued on the point of ratio decidendi. On that ground, Mr. Dhora has argued the ratio of decedent.
Yes. They should.
On that ground, Mr. Dhora, sir, if I correctly memorize.
Ratio decedent. Without argument, ratio decedent of what? Ratio decedent.
It was the submission on the part of the commission through Mr. Dhor that the ratio decidendi of the appeal is no way connected with the subsequent interlocutory applications. That was his argument.
Correct. That is different thing, right? It is extension application, include application, those cannot change the order passed finally by the court while disposing of the lease. Yes, it says so.
Draft of argument of Mr. Dhar
Hmm.
was the finding arrived at while disposing the appeal is to be looked into, and the finding arrived at by the same division bench or division B, that is made while disposing the interlocutory applications need not be looked into because those findings are never ratio decidendi in the appeal itself. That was argument of Mr. Dhar.
The finding of the appeal court and single bench on the ratio decidendi, whatever, there is ratio decidendi for that finding. The subject matter of lease between the parties. Subject of lease. And that has been decided on a ratio decidendi. Right or wrong? Single bench, appeal court. Appeal court ratio decidendi is, I am not disturbing the order passed by the single bench. But because
Then how do we interpret the finding of the division bench in the order dated 13/6/2020? That I intend to know, sir.
Can you see, this is the thing. Division means paragraph 13. Where division? Can you see? Kindly come to paragraph 13.
Yes, sir.
3 minutes. Because division is not never said so. We are unable to accept the contention of the applicant that a plea was taken that there has been a large discrepancy in the scrutiny process, and therefore authority have decided to make a fresh scrutiny so as to invite several other eligible candidates to participate in the written examination. We're unable to accept the contention of the applicant that plea was taken before the division bench or single bench. May I read it again? It has been
Such plea was never taken.
a plea, we're unable to accept what? Not that ground is plea is good or bad.
Such plea was not taken.
That's right.
Practically, that is saying.
We are not saying we're unable to accept the correctness of the plea. Unable to accept the plea, the factum that the contention of applicant, the plea was taken. That court is not accepting. The plea was taken before the single bench or division bench while disposing appeal. This has been considered to be ground. They are unable to accept the plea. Very well. Therefore, the court is extending their time on the basis that no such plea was taken. No such, what the plea? Discrepancy in the scrutiny. That plea was not taken before single bench and division bench while disposing appeal. Yes, correct. Apparent from judgment is not taken. But on that basis, parties are arguing before Lordship that court directed that no second written will be held. This has been not, has to be raised properly. And having regard to the mind, that court is extending only considering whether ground exists for extension, not whether order passed by the single bench was right or wrong. See, now can you say paragraph 17 now? They have relied upon strongly. See the paragraph 17. It speaks otherwise. We would have proceeded to reject the said application. That therefore no ground has been made out for extension of time. No sufficient ground. But considering the plight of the candidates, that is not what the Court of Equity steps in. Plights of the candidates who have participated in a written examination and because of the careless conduct of the authorities, their fate is still in large, or in other words, uncertain. We feel that the authorities must act strictly in terms of the order passed by the single bench as affirmed by the division bench. Full stop. Full stop. We are unable to comprehend the stand of the applicant that further written test is required to be conducted when the same was not accepted by the single bench as well as the division bench, and the direction was plain and simple. Then after conducting the written examination, answer script are to be evaluated. What does it mean? The division, after conducting the written examination, answer script are to be evaluated. And so,
Mr. Mitra, according to you, what would be the implication of this finding?
Implication of finding, Milord? Well, in humble submission, conducting written examination is not prohibited. On the other hand, court while extending it mentioned the word after conducting written examination. Now next contention is whether from that can it be
No, Mr. Mitra, I'm sorry to interrupt. Here it has been written further written test.
after
Yes, sir. Can you read?
no after conducting
We are unable to
examination.
comprehend the stand of the applicant that further written test is required to be conducted.
Yeah, and to be conducted, the same was not accepted by single bench.
Then what would be your submission with regard to this finding?
This point, this is not a finding. It's not a finding. Can you see me now? This part. If it is while extending court, now, first of all, say below, we feel that authorities must act strictly in terms of order passed by single bench and affirmed by division bench. Correct? Correct. The next, we are unable to comprehend the stand of the applicant that further written test is required to be conducted when the same was not accepted by a single bench as well as division. Why is that? Which single bench order said so? Which division bench order said so? And then they add, and direction was plain and simple, that after conducting written examination, answering valid. And they say, direction of the single bench was that written examination had to be conducted. And no single bench or no division bench has said that further test, written test is required or not. Now, here comes the question, my lord. It is not an obiter dictum. Not even an obiter dictum. Obiter dictum means a finding on a question of law. That is why, my lord, obiter dictum of Supreme Court is binding on High Court. A question of law is binding, not a question of fact. Question of fact is never obiter dictum. Can never be a dictum. That is not binding on any court or any party actor. Now, if the order is interpreted in that manner, this order, extension order, my first submission is that extending court has no jurisdiction to any way modify the order of the single bench, having confirmed that, etc. Number two, the order of single bench and division bench disposing appeal. It cannot be implied. Mr. Dhar has made a valuable submission that you can imply something from an order if that is legal, if that is possible, if that is legal. You cannot imply from an order to say the court has directed you to do something illegal and make that order illegal. Why I say so? The fact remains that 73,000 eligible candidates have not been called for written tests. Those 73,000 candidates were not parties to this application for extension. Is it fair on the part of anybody to argue and to hold that the court, a court of justice, passed an order against non-appearing party to whom no notice was given, were not parties to the suit, fatally affecting their fate, affecting them prejudicially?
Then I am putting same question to you which I put to Mr. Dhar.
Yes, madam.
If the conscience of the commission was so strong, what prevented them to approach the sales and division bench in the review that this is the illegality or irregularity I have committed?
Yes.
Allow me to hold the further written examination.
Review when lies. Review when lies. When there's review of the order of division bench or single bench, when there's error apparent on the face of the record of that order. What is the ground of saying?
Sufficient grounds it will not cover.
That is Jerusalem generis to the main thing. That is Jerusalem generis. It is what the board will, commission will show is
very good. Then the subsequent discovery of facts.
Subsequent discovery of facts. Very good.
This is subsequent to that.
Very good.
Subsequent to the disposal of the appeal, sir.
Yes, maybe. I do not know what this is the main thing, Lordship. It's not known to your Lordship when the facts were discovered.
From the very beginning,
Yes, but when the facts were discovered. Yes, ask that question to commission. When the fact was discovered. When this mistake was discovered.
The mistake was discovered. The mistake was discovered at least prior to passing of this order. That is on
single bench order.
No, sir. That is while immediately prior to or at the time of filing CAN 20 of 2020. Take your seat, sir. I've heard you. Don't interrupt.
Yes, right. They're discovered on what basis that the inference is being made.
Let me have an audacity to travel, Mr. Mitro.
My lord.
Let me have an audacity to travel, Mr. Mitro.
No.
With my brother, what will say? I with my dull brain.
I'm a counsel, now. Where from that deduction is being made? Nobody's case is that. That is discovery of fact. Can you take order 47 rule 1?
Yes, sir.
Discovery of subsequent event will create an error in the order of court. Order is even who has
discovery or who from the discovery of new and important matter of evidence which after exercise of due diligence
taken place
not within his knowledge or could not be produced by him at the time when the decree was passed or order made or an account of some mistake or error. I will not go that or for any other sufficient reason. But on the first ground, sir.
First ground, excellent. May I read only once more?
Yes, sir.
Can an order be said to be erroneous on the basis of event or facts which are not before the court at that time? It says the facts which were there in existence at the time order was passed, but subsequently discovered by a party, and which he could not have discovered earlier by due diligence. Now read the 47.1. An order of court will be condemned as erroneous because subsequent something happened. Is that we have to argue this point? Can you order 47.1? See, that's what said. Fact was there, event was there, but the reason was there. But when the order was being passed by the court, but that could not be discovered by the parties appearing.
Sir, I'm again traveling. Please excuse me, sir. Try to visualize the situation.
Yes.
Try to visualize the situation. Please pardon me for my audacity, sir. Sir, try to visualize the situation. Before the single bench, Malakar approached for non-publication of the result. Single bench, the coordinate bench passed a direction to prepare panel, call for blah 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 that you have placed. If he is found to be successful. Challenge was made by the commission before the division bench, and at the time of hearing, the commission practically abandoned the ground of appeal, wait for extension of time. So, on the day of disposal of the appeal before the division bench, the alleged deprivation of 73,000 was not known to them. The commission again came up before the division bench on account of their infrastructural lacuna, maybe on account of inadequacy of logistic. They could not publish the result. Extension was granted. Now they have come with a different stand that on account of technical mistake as quoted by quote unquote by Mr. Dhar, allow us to grant further time so that we can take re-examination. The division bench unable to comprehend the stand of the commission for holding further examination. However, on a humanitarian ground, the matter, the time was further extended for certain period, 6 months or so. So my point is my point is that at the time of filing that CAN, the commission was aware of their alleged technical flaws. Yes, sir.
Yes.
So those flaws, those technical flaws comes within the periphery of discovery of new and important matter of evidence. Had it been known to the commission earlier, at the time of hearing, the appellant commission before the division bench must have raised that grounds in the appeal. That has not been taken. So even then you are saying that it is not a fit case for ground of review.
Now all my learned men who are opposing this, they say that this technical flaw or mistake was discovered after disposal of the appeal. They are all saying that very vehemently, paragraph 3 or something, you said that. They have discovered this mistake after disposal of the appeal.
Naturally.
Yes. Now read order 47. Whether that could be brought in to notice of the court while disposing of the appeal.
No, it cannot. That is why I am talking about the review, sir.
Can they come to me, section order 47, rule 1? Submitting a first part. And
yes,
from discovery of a new and important matter or evidence, which after exercise of due diligence was not within his knowledge and could not be produced by him at the time of the decree was passed. The fact was not known to them.
That exactly that I am on. So that is a ground of review.
Can review. Whether
we are reading order 47 rule 1, no? It's a review.
No. Yes, I'm reading that. Provided that ground that produced exercise duty was not within his knowledge and could not be produced by him at the time when the decree was passed or was order made or on account of some mistake or etc. on the period. Whether after which important matter or evidence, which after exercise of due diligence was not within the knowledge and could not be produced by him at the decree. Whether this mistake was not discovered by them.
Sir, exactly. I am with you, sir. I am with you.
Yeah.
Had it been within the knowledge of commission at the time of hearing of the appeal, they could have taken it. They could have taken it even by amendment of the memorandum of appeal. It was subsequently noticed by them. It was subsequently discovered by them, which is why they have preferred the CAN 20. They remain unsuccessful.
Yes.
Even then, they have not come forward with an order 47.
Yes, they have not chosen to apply for review of the order of the appeal court or single bench, which took place in the year 2022 matter over. Now, does it mean review is not been done? So, what follows from that? Assuming review could have been made, this exercise of due diligence, was this mistake discovered or could be discovered within the time when the appeal was heard? The commission was defunct for a period of 5 years. According to COVID, affidavit, COVID was 2 years old. 2 years. So what is the case made out by any party here? That is mistake which is discovered by the board could have been discovered or could have been discovered by exercise due diligence in 2018. That case has to be made out. If order 47 rule 1 applies, then see me now the language is which after this exercise of which after exercise of due diligence was not within his knowledge or could not be produced by him at the time. I'm saying so. Was the exercise that was going on from 2015, the commission is defunct up to 2020. These are all question of fact. Question is when it was discovered, and question is whether that could have been discovered earlier. Two things appear. Whether this exercise of due diligence would have been discovered in 2018. Which led to a discovery of this mistake when the resolution was passed in 2000, the date has been now given, to correct the mistake.
Very good, sir.
It's a question of fact. Now, let's kindly come to the question, review not made. So what? What follows from that? Order remains binding without any modification by the court. Lordship is considering whether the extending court has modified the order. Exactly, that's the question they are now raising. Reading the order as it is, of single bench and division bench, there is no dicta that don't hold any other examination if any situation arises.
Very good, sir. Come to the next point.
Now, the next point is, if the court implies or draws the implication from the order of our division bench or single bench, that will be rendering the order illegal. Because the party who have been 73,000 examinees who had right to be called for written examination were not parties before in that proceedings. They are not made parties to that proceedings. And in that proceedings, court could not have passed any order affecting them. Same thing applies in this proceeding also. The petition which they have now made without impleading the affected parties is totally illegal and it is to be dismissed in the meaning. Court, it is not in humble settled law that no court has the jurisdiction to pass order affecting non-parties to whom notice has been given. This will not apply to the order of the single judge and division bench if such implication is raised. And Mr. Thor rightly said, deductions can be made, which will be lawful deduction. It would not be lawful to deduce that our division bench or single bench would have passed the order affecting those successful candidates in that skin test and asking them or depriving them of the right to appear in written test. Same thing appears in the current proceedings. None of the parties, none of the successful candidates have been made parties here in these proceedings. No notice has been given to them. No step for making a representative action has been taken. This order is totally pushing bad. My humble submission, my Lord, please to dismiss the writ applications, all the writ applications on this ground alone. Lord, may I? There are several judgments. Lord, I am to cut short the matter. I am relying on 2014, volume 16, Supreme Court cases, page 187. There is no paragraph. Paragraph there, I read the judgment. You could have told it. Copy of just like it? Yes, sure. Huh? Very important. Because I thought you should avoid citing so many judgments which are referred to here. Yes, madam, must be aware of this.
Yes.
কপি আনতে পারবে
দেখুন।
নিয়ে এসো তাহলে।
আমার কাছে থাকতে পারে,
হ্যাঁ?
আমার কাছে মনে হয় আছে, দেখছি।
দেখো দেখো দাও।
রঞ্জন কুমার।
নামটা
রঞ্জন কুমার।
রঞ্জন কুমার।
পেয়েছো?
রঞ্জন কুমার।
আনো তাহলে দেখুন। Then I will go to another topic. So that the
Give me a second, sir. Give me a second.
is an application, represent read application.
Lordship is using the iPad, so I can airdrop. I mean, I can use a Bluetooth directly. It can go there without anything.
This is not fair on court. This is not fair on court.
Give me a second.
Should I send?
No, not required, sir.
Not
If I require, I will.
And that is gracious enough to read from that. And got it, Miller.
Give me a second, sir.
Exactly, facts are similar. The writ petition, all the three writ petitions have to be dismissed on this judgment. Some parties were made parties in this case. Some of them.
This is not right, no?
এটা নিয়ে আসবো। Thank you. Very kind.
Yes.
In this case, below, some of the successful candidates were impleaded.
Ranjan Kumar and others, no?
Ranjan Kumar. Well, may I now place it, Miller? Then, by humble request, Miller, use this, but don't use it too often. It affects your eye. It affects eyes. But do it.
It has become now an integral part of our life. What can be done, sir?
And Miller, it has.
Space is real problem nowadays.
Yes. And it has.
And maintenance of libraries, sir.
Yes.
Since my family belongs to legal fraternity, and sir, and my mother has a chairman.
That's
Nowadays,
and when I find my juniors bad, Mr. Thor and others, all have only one.
We don't have other option. No option. No option, sir. No option.
But it is when a strain on eyes. Don't do it. And I am grateful to your lordship for also taking the trouble. It was our duty to give a hard copy. But very gracious of you, Lord. May I read this judgment now, Lord? Should I? In these appeals, Assel issued a judgment and order dated 1920, passed by the High Court at Patna, in a batch of letters patent appeals, in our case, same thing, whereby division bench has concurred with opinion expressed by the learned single judge, wherein he had quashed the appointment of number of appointees in respect of post, namely these four. Same prayer they are making here. Quash the appointments. Same prayer. on the ground that the procedure adopted for selection was vitiated, as the candidates were selected only by interview without holding any written test, though the past practice was to conduct an examination and thereafter hold interview for selection, that the interview was held in a hurried manner and that the post being technical, selection procedure was bad. Same thing, the procedure bad here. Same ground. We need not state the facts in detail. Suffice it to say, as in pursuance of an advertisement issued by the department concerned of the state government, 182 persons were appointed, in our case 297 persons, on the post of MLT. A lead petitioner who participated in the interview could not be selected, same thing here also, as they obtained lesser marks than the successful candidates. Their failure necessitated them to knock at the door of the High Court, and the learned single judge, as has been stated here before, accepting the grounds put forward, quashed the selections. The learned counsel for the appellant have raised two principal contentions. First, most of the appellants herein were not pleaded as respondents before the High Court, and without taking note of the said aspect, the High Court has invalidated the selection and nullified their appointments, which is violative of the principle of natural justice. And second, all the private respondents who were writ petitioners before the High Court, having participated in the interview, which was the procedure adopted, could not have challenged the said process in the court of law because of that failure for them. Both these grounds are taken by the commission in their affidavit. I'll place a paragraph. Ground of it may not all, but ground taken. On a perusal of the order impugned, we find only 40% were made respondents. In our case, none. And hardly a few appointees filed application for intervention. It is well settled in law that no adverse order can be passed against persons who were not made parties to the litigation. And that is the implication they're asking the lordship to draw from the division bench order. The division bench intended to adversely affect the successful candidates from participating in written tests. That is the inference. That will be, I will submit that no deduction should be made of a court order which will render the court order unlawful. Unlawful. This is what they are trying to do. In this context, we refer to the authority in Probodh Padmama state of UP. That is a bench judgment, wherein three-judge bench was dealing with the constitutional validity of two Uttar Pradesh ordinances which had been struck down by the division bench of the Allahabad High Court on the ground that the provisions therein were violative of Article 14 and 16(1) of the Constitution of India. In that context, a question arose whether the termination of services of the appellants and the petitioners therein as secondary school and the intermediate college lecturers following upon the High Court judgment was valid, without making the said appointees as parties. Learned judges observed that the writ petition filed by the Sangh suffered from two serious, though not incurable, defects. The fourth defect was that of non-joinder of necessary parties. For respondents to the Sangh's petition were the state of Uttar Pradesh and its officers concerned, and those who were vitally concerned, namely reserve pool teachers, were not made parties, not even by joining some of them in a representative capacity, not even by joining some of them by representative capacity. Considering that their number was too large for all of them to be joined individually. The same has not been done here. Thereafter, the court ruled, matter therefore came to be decided in their absence. A High Court ought not to decide the writ petition under Article 226 of the Constitution without the persons who would be vitally affected by its judgment being before it as respondents, but at least by some of them being before it as respondent in a representative capacity, if their number is too large. Therefore, Allahabad High Court ought not to have proceeded to hear and dispose of the Sangh's petition without insisting upon reserve pool teachers being made respondents to the writ petition. or at least some of them being made respondents in a representative capacity. And had the petitioners refused to do so, ought to have dismissed the petition upon non-joint mandatory parties. It is not possible in respect of the main list now. Now, paragraph 5 is summary of law. In this case at hand, neither was any rule nor any regulation challenged. Same thing here. In fact, we have been apprised that all the time, selection and appointment, there is no rule or regulation. It is wrong. In our case, there is. A procedure used to be adopted by the administrative instruction. That apart, it was not a large body of appointees, at only 182 per appointment. Quite apart from that, persons who were impleaded were not treated to be in representative capacity in the regard government. 40 persons were impleaded, 40 of them successful candidates. Even then, since they are not impleaded in representative capacity, it was held to be bad. In our case, nobody. Then these judgments are, so many judgments have been referred to for the same proposition. I am citing judgment for avoiding citing so many judgments. In first judgment referred to is Indu Shekhar Singh. There is another aspect of the matter.
Rasmi Mishra.
Appellant herein were not joined as parties in the writ petition filed by the respondent. In their absence, High Court could not have determined the question of interceding. In the proceeding before the Justice Pratik Prakash Banerjee and Justice Division Bench, the writ petition number, none of those appointees or successful candidates, if they are there or not, or prospective one, they made parties. Only commission. And order is supposed to have, if is now held that by that order, not directly but impliedly, High Court had directed that no written test will be held, even for the successful candidates, that will be violation of natural justice and void. And my humble submission to your Lordship and to my learned friends also, that don't impute such inclination to pass illegal order on the part of any High Court judge, of our High Court judge at least. It is not permitted to think that court will pass an adverse order against parties without making them notice, and that by implication you imply that. That is not so. If I may know, this is causing counter. Next, we know Rashmi Mishra, after referring to another judgment of Supreme Court, huge number of judgments have been quoted here. In West Bengal case, paragraph 8, this court approved the view exhibit tribunal which had opined that for absence of selected and appointed candidates and without affording an opportunity of hearing to them, election could not be set aside. Could not be set aside. In West Bengal case, it has selection. Paragraph 8. In Public Service Commission, paragraph 2212 SCC, this court, while dealing with this concept of necessary parties and the effect of non-implementation of such party in the matter when the selection process is assailed, observed thus. Udit Narayan Singh's case, wherein the court has explained the distinction between necessary party and proper party and pro forma party, and further held that if a person who is likely to suffer from the order of the court and has not been impleaded as a party has a right to ignore the said order, as it has been passed in violation of principle of natural justice. More so, proviso to Order 1, Rule 9 of the Code, hereinafter Code, provide that non-joinder of necessary party be fatal. Undoubtedly, provision order court are not applicable in its jurisdiction. Code not applicable. By virtue of provision section 1% of the code. But the principle enshrined therein are applicable. Then judgment of Supreme Court referred. The next judgment is Jadhav versus State of UP. No order can be passed behind the back of a person adversely affecting him, and such an order, if passed, is liable to be ignored, being not binding on such party, as the same has been passed in violation of natural justice. That unfortunately, my lord, even before your lordship, when the matter was moved for interim order, it was not pointed out to your lordship that this order cannot be passed because of the affected parties by the order to be affected by the order which will affect the parties are not at all implemented. Had it been brought to my lord's notice, I am sure lordship would not have passed any order. That order in violation of natural justice. That don't allow the successful candidates to appear in the second written power. No doubt lordship will have. The court knows the law, but court has to be alerted on some points of law at the relevant time. Otherwise it's not possible that the busy schedule of a judge to appropriately remember it. Court has to be apprised. That's our job. That's the council's job. That these are the possible position of law. And I have no doubt, with humble respect to your lordship, that would not have passed that interim order had your lordship been told that the parties who affected are not implemented. The order, when invited from lordship in violation of natural justice, which according to Supreme Court is void order. That order, I have no doubt also recall that order and vacate it. Then Vijaya Kumar, Union of India, etc. And then as I highlighted, no dispute of factum of sovereignty. Lordship is
Actually, 3-4 মিনিটের মধ্যে চলে আসবে।
quoted is come up to paragraph 13. You can read it, paragraph 13. In view of the aforesaid enunciation of law, we are disposed to think that in such a case, when all the appointees were not implemented, the writ petition was defective and hence no relief could have been granted to the writ petitioners. So this is a judgment citing not only for this dismissal of this writ petition, but also to persuade the court not to draw the inference or implication that the division bench held that if the successful candidates are not to be allowed to participate in testing because they are not parties. And if the division bench held so, my lord, this is not obiter or anything. I'm saying there is no dictum, no question of obiter here. Then that will be a void order. That will be a void order. To that extent, but by first submission, division have not held so. You can say after holding written contract. Let's think it is the second part of his judgment. Second part of the judgment, paragraph 14. Another ground for dismissal of the writ petition. Paragraph 14 at page 192. Of this 14. The next submission, which has been presented before us, is that when the respondent had appeared in the interview, knowing fully well the process, they could not have resigned later on or taken a somersault saying the procedure as adopted by the department was vitiated. In this connection, it is apt to refer to the principle stated in Om Prakash Shukla's case. In a said case, a 3-judge bench taking note of the fact that the petitioner in the writ petition had appeared for the examination without protest and filed petition only after he realized that he would not succeed in the examination, held that writ petition should not have been granted anywhere. I'll show Miller from their own case. Writ petition knew they participated. Is Mr. Bishop Vishnu he had participated in the second written test procedure. He has participated. And when his name did not appear in the aptitude test, then he applied. Unsuccessful candidates can, after taking the chance, cannot appear. In this context, we may quote passage from Madan Lal. It is now well settled if a candidate takes a calculated chance and appears at the interview, then only because the result of the interview is not palatable to him, he cannot turn round and subsequently contend the process of interview was unfair or as a selection committee was not properly considered. In Om Prakash Shukla's case, it has been clearly laid down by bench of three learned judge that the court that when the petitioner appeared as an examination without protest and when he found that he could not be succeed in examination, he filed a petition challenging a said examination. In another Chandra Prakash Tiwari's case, there is no doubt that while question of any estoppel by conduct would not arise in the contextual fact, but the law seems to be well settled that in the event of a candidate appears to be interviewed or participate therein only because the result of interview is not eligible to him, he cannot turn round. Then Union of India, that both and petition are dismissed. Now, in this connection, the question raised, questions occurred in course of discussion. See the affidavit, comprehensive affidavit of the commission. Paragraph, page 21. Paragraph, page 20, Dr. Can you see? That is the commission's view. The court has not addressed. Has not addressed. Paragraph, page 20, after the quotation, but we Second of this 13 June order who has been quoted. Can you see middle of that? Page number 20 below. 20. Just before the quotation. Let's go to the quotation. The Honorable Division Bench considered can number 20 of 24 was pleased to pass an order 13 June and the following observation. Taking a pragmatic view of the matter, we extend the time for a period of 3 months from the date of completion strictly in terms of order of single bench activity. By such order, Honorable High Court has not restrained the recruiting authority from holding the written examination of 73,000 candidates who were successful in the preliminary examination held on that could be allowed to sit for the written examination held on, etc., due to the technical error of the Commission in earlier evaluation of mobile sheet. Subsequently, we published a notice of the holding an examination who were successful. Now, then the next page is important. When this mistake dawned on 30th July 2024, the recruiting authority published a notice. Can you mark the date, 30th July, to complete the first Group D examination within 10 September 2024. Thereafter, by a notice dated 4th August 24, Commission published a list of 24,577 candidates who appeared in written test of first SLST held on 29/5/2021. And on 5th of August, published a list of 73,978 candidates who were successful in the preliminary screening examination held on 20th November, but could not get the opportunity to appear in the written examination due to technical fault and error in evaluating the OMR sheets of the preliminary screening exam. Admittedly, no fresh candidate has been called for or allowed to participate in the written examination except the applicants who appeared in the preliminary screening test examination held on 28/11/2010 and were eligible to appear in the subsequent written examination. Subsequently, a notice was published on 11th August 2024 for holding written examination on 1st September 2024. It was issued. They all knew notice was issued. The second exam. Why not come to court then? Allow the examination to be held. See, my lord. The next written examination of 73,000 left out candidates held on 1st September 2024. Commission has not violated the observation made in paragraph 13 and 17 of the judgment and order themselves. As no further written examination of those 24,577 candidates who had participated in examination held on 29 November was conducted. This is the view taken. No further examination of those 24,000 candidates who had participated in the written examination held on 29/5/11 was conducted. In fact, the Commission on 1st September 2024 conducted the written examination of those 7,578 left out candidates who could not get the opportunity to appear in the written examination held on 29/5/2011 due to a technical fault and error in evaluating the OMR sheets of preliminary screening examination. So the written examination held on 1st September 24 is neither a further written examination of those 24,000 candidates who had participated in written examination held on 20, nor any written examination in any candidate. Result of both written examination held on 29/5/11 and the candidate 22 was published jointly by taking all candidates of both written examination together on etc. and a list of 3,233 qualified candidates were selected for personality test as per merit, and the set was published along with a list of final vacancy containing total. So it was published that they knew that their name, they had not been invited for aptitude tests. So they had not been successful, they knew. But the post of Group D, etc. The personality tests were held on 18th September 2024 to 30th September. Subsequently, final merit list by notice dated 4th October 2024 and the date of counselling was by notice dated 5th October 2024 was published. The Honorable Division Bench, in terms of the judgment and order dated 13th June 2024, has not restrained the recruiting authorities from holding the written examination of 73,978 candidates. There were no irregularities. And my only addition in law is, please don't infer that, because that will make the order of division bench extending court unlawful, void, and violative of natural justice. Therefore, my lord, you cannot, court should not reduce or imply such order as would render the order unlawful. Protocol application, etc. all annexed. This is the fact now they have said. So when the mistake was discovered, it was 24. There is nowhere it is stated, and there is no ground to think that the mistake was discovered in 2018. The case was heard. And nobody said, then see the case back. Has anybody alleged? If I reply to this, I don't have copy, don't reply. Kindly see, have anybody alleged that this mistake could have been discovered by the Commission by exercise of due diligence in 2018? Then question of review arises. It's a question of fact. Kindly remember, my lord, 2015, 2020, the Commission was defunct. These arguments on facts cannot be made which are not on record and which are not plausible from the records. I agree, my lord. My lord has said, my lord, but if a fact which could have been discovered by the board, by a party, by exercise of due diligence, when the order was passed, but could not be done, because you then arises for review. But then also can only consider that if I has not accepted the review, what does it mean? If I have failed file application, then I'm Commission accepting the order of a single bench. That's the highest. And accepting order of single bench, that's all. Commission has always accepted the order of single bench, rightly or wrongly, according. And division was directed complaint order. So how is relevant to think that review was not made? Review was required to be made if the board thought that the order of Justice Pratik Prakash Banerjee, Milord, it restrained the commission from holding the written test for successful 73,000 candidates. Would I express the affidavit? Both can never consider that to be so. Even now, that is not a board case. So why the board should apply for review when board did not think? So again, board
No, sorry.
Commission.
Board commissions.
Why the commission?
Recruiting authority.
Commission, when did not think that the single bench had restrained them from considering 73,000 successful candidates to be allowed to be taken. Then on what ground board will apply for review? For review, Milord, now comes the question of why board could not apply for review. I'm trying to answer my last query. When now humbly tried to answer that. Board could not apply for review because it was never the case of board that a single bench order suffers on any error apparent on the face of the record. That single bench order, a division may confirm, had restrained that board from holding the written test for the successful candidates. What review application made, board has first said that by this order, what is the error? The commission has been restrained from holding written tests for so many candidates. Then only board could apply for review. After the application of review for correcting error on record, a mistake on record. But board is not saying that was a mistake. Board is saying, no such order was ever passed. It was not a board case, there is an obiter dicta. An obiter dicta cannot be about a question of fact. Board case says, no, that was not the order passed by the board, by the commission. And if you argument made, kindly don't listen to it. Well, affidavit, that is the case of the board. Then how could they apply for review? My humble supposition is, board could not have applied for review. Because according to board, there is no error, no such error on the part of the High Court restraining successful candidates from appearing in written tests or often in it.
Yes, sir. Any other point?
Well, let's raise judicata. Question raise judicata. Court, this order of division bench, he said, only what was the res judicata there? He is in for judicata what? Res for adjudication was whether ground existed.
No. Res judicata point was never raised by the writ petitioner.
No,
it was raised by the court, and
Oh,
subsequently it has been noticed on perusal of the relevant section
I
10
did not address it.
that it was not.
No.
It must be between the same parties
I
or litigating under the same title. So
no,
we
I'm not-
rest assured that it will not be reflected in my judgment.
My main question is this was not for adjudication.
No. It was never raised. It was raised by the court in course of argument of Mr. Thor, and subsequently I noticed that it is not applicable because it is neither in between the parties nor litigating under the same title. So you need not argue, Mr.
That.
Don't waste your time and energy over that.
Now, board has filed the examination written papers, question papers, and have submitted. The standard of second examination remains same. That's sufficient.
Level playing field.
That they have submitted. I am not seeing the exam paper. I am not a party to these proceedings. I am not. But that's the observation that I accept. I will not dispute with that. Now, Lord, kindly, what is the next point left? That Next point is not the division bench order of the 13th June could be read as the order of a court
Yes.
Now, my lord, kindly see page 114 of the affidavit. What are the marks? 50 marks was the
Affidavit of
board.
composite affidavit. Page number, sir?
114. Yes, to apply your lordship, that the question marking was this. Preliminary screening examination maximum 30 marks out of 50. Written examination 15 marks only. And personality test 5 marks. And see the breakup of this 15 marks. Most marking on the preliminary screening examination, Group D stuff. And got to get the breakup of 15 marks at page 119. Even the 15 marks at last paragraph of page 119. For the post of Group D staff heading. Written examination. Question in the written examination will be 1. General English 8 marks. Arithmetic 7 of class 8 standard. The test will be 01 hours duration. 8 and 7. Arithmetics 7 and English 8. Group D staff. Now, having done them, I only point left with me to deal with. Let's get. No level playing out argument. I did that. No level. What is meant by no level playing out? You have relied upon a judgment of the Honorable Supreme Court. No level playing ground means that all successful candidates at the preliminary examination screening are allowed to sit in written examination. Level playing out would have been affected if out of, let us say, 73 plus 24,000 successful candidates in the screening test, only 24,000 is allowed to have seat in the written test. Then there will be discrimination and no level playing ground. No level playing ground is based on the question of discrimination. Has been discriminated. Now, there would have been discrimination and no level playing ground had out of 73 plus 24, let us say 1 lakh successful candidates, only 24,000 was allowed to sit in written text and balance 70,000 was not allowed to sit in written text. Therefore, it is allowing written test to the remaining successful candidates is creating the level playing ground. Next point is, and what is the rule of the game? Rule of this game is that there can be separate tests for the candidates. The preliminary screening test, which held the highest mark of 30, was held in 3 zones. And 3 zones were given 3 different questions. That is the case. And that is an affidavit also of the commission. So rule of the game in this game was, yes, the different written question papers could be framed for the same group, for entire examining group. And that is how this game started. That lordship will find affidavit paragraph to dig it down.
Mr. Mitro, the argument of the learned advocate for the writ petitioners,
Yes, Milord.
that in order to achieve the correct level playing field, you must be backed by rules and regulations.
Yes, correct.
So far, my recollection.
Absolutely true.
And for holding examinations on different question papers on different shifts, you are also required to be backed by rules and regulations.
Yes. And other,
Sir.
Oh, bless Lord.
And they have referred the case of Aditi, where the Honorable Apex Court,
Supreme Court.
while the Honorable Apex Court
Yes, Milord.
expressly held that holding examination in two seats would invariably enable arbitrariness and would not entail at par evaluation.
Yes, I'm aware of that.
Holding examination in two seats would invariably enable arbitrariness and would not entail at par evaluation.
Now, my Lord, absolutely not. I'm grateful to my Lord. Coming to that, so there's questions. One by one, if I may deal it one by one. First, Milord, there is no.
Now, in this matter, everyone is having an excellent learning experience. Everyone. Yes, sir.
Now, Milord, first question, the regulations. Absolutely.
That was my question.
Yes. Yeah. First question, rules and regulations do not prohibit holding of multiple written tests.
That has been argued by Mr. Thor.
Argument Mr. Thor has shown you a lot.
Yeah, on the basis of the proposition of General Causes Act.
Singular includes plural. Yes, I will go judgment. General Causes Act, I have got the section noted. I can give the section.
Settled question.
Therefore, there is no prohibition under that. Now, knowing the regulations, they will participate in the preliminary examination.
Though that is undisputed, sir. That is undisputed.
Yes. And they knew that different question papers for three different zones. Then they did not think it was violative of rules or regulation. They started with this rule of the game that there may be different tests for different categories of persons. So there is no change of rule of game here.
Sir,
It's the second question.
I must be very frank, honest, and fair that on perusal of the question papers for the written examination as held on 29/5/2011 and as held on 1/9/2024, I find you people say the courts are experts of experts. Level playing field are maintained. That I've noted.
Okay.
So be rest assured that
Yes.
that is my finding. It's not prima facie finding, it's an inconclusive finding.
Now, Milord,
Question is only whether you are backed by any rules or not.
it not be.
You are backed by any rules or not.
That should be backed by.
And in that context, I have stated to Mr. Thor, so if my recollection goes rightly, that everything cannot be stated in acts, everything cannot be stated in rules, but every action of the commission must be backed by at least by a resolution of the committee prior to holding the examination. What I troubled Mr. Thor, that prior to holding the written examination dated 29/5/2011, had the commission taken a decision that they will take written examination in 2 or 3 phases. That question I have asked Mr. Thor.
Mr. Thor, may I also try to answer the question? May I only, by Lord's kind permission, say expression, whether backed by the rules, I like to say whether prohibited by the rules. Backed by the rules means it must be express prohibition, express provision that written test can be held twice. I am only trying to modify with minor kind, but for minor kind acceptance. The test would be whether it is prohibited by the rules.
Sir, absence of no can be absence of no can be termed as can be interpreted as an yes.
Yes.
Can the rule of game be can the rule of examination can be altered when the game starts or examination recruitment process starts?
Cannot be, and it has not been altered.
Cannot be.
Has not been altered in this
Cannot
case.
be.
Yes, but agree with what I told, respectfully agree. Now let me.
Had it been such a case that noticing their own defect, the commission have taken a decision that they will cancel the earlier examination and they will hold the entire written examination afresh, it could have been otherwise. Question is, again on level playing field has been maintained. Question is whether holding of second phase of examination, even maintaining a level playing field, is at all permissible in the perspective of the acts, rules, and the action of the commission prior to selecting the mode of examination.
No, this is where the crux of the.
I believe I'm not. No, my question is not irrelevant.
No, question totally relevant and quite lucid, if I may humbly say. Now I am in a position to make my humble submission on that. If they're really silent on the subject, then what will happen? Lordship, I have cited a judgment already. Then administrative discretion comes into play. The judgment, you can take it, the judgment that was cited today. If the rule is silent on a point, then administrative discretion holds the field. And the administrative body has the discretion to do this, fill up the vacuum. That's why I humbly submitted. Please don't say whether backed by the rules, but see whether it's prohibited by the rules. Then it is illegal. It's contrary to rules.
So your contention, Mr. Mitro, that holding of written examination in two shifts were not prohibited by the rules.
Right.
That is your contention. Very good. I understand. Thank you.
Then, this general causes act, etc. But there is no prohibition clause. Next, Miller, what is the rule of the game in the absence of that? In the absence of it, the commission in this case have set up the rule that in this selection process, there will be different sets of question papers for different candidates. And the screening test, which had highest mark, that's why it was 30 marks out of 50. The screening test was held by submitting 3 different sets of question papers.
Sir, I will not go to that point, sir.
Why not?
I will not go to that point because that was not question. That was not question.
That
is not the subject matter of the news.
Correct. That's it. This
I will adopt your contention that they have acquiesced to that. They have the petitioners acquiesced to that. They will not. I will not allow them to.
That's the
question is holding up. You have stated that holding of written examination in 2 shifts were not prohibited by the rules. That I understand.
Actually, there is no change of rule of game. Customer admit that. We'll accept that. Because
I'll accept or not, that will be reflected in my judgment. What I have accepted, that I have disclosed.
But in case of
what I have accepted, that I have disclosed, and what I will what I will decide to accept, that will be reflected in my judgment.
That it is also made with politeness, having said, "Who do not keep the points up their sleeves." Who do not keep the
No,
points
no,
up
I'm
their
to, I'm to come to a logical
No,
conclusion of
but
the same
that is what
to the best of my ability, of
No,
course,
no,
sir.
not Cali. Now, look, my submission is this, that in this case, board has rightly wrongly set up a rule of game that there will be different test papers, question papers, for different zones of candidates. So, findings, different question papers, different sets of papers is a rule of game in this. And knowing that, they have participated in that. Therefore, if there could be the different sets of written papers, written tests, for the highest mark, 30 examination, then why not of 15 marks? Written test. Why they can say so? Because that then nobody has pointed out, rightly made out, that they've acquiesced in that. They accepted the rule of game, right or wrong.
But here they have not acquiesced.
Therefore, they cannot later on say.
But here they have not acquiesced.
This is
In the
beginning.
written examination, they have not acquiesced.
The game started, the rule was that there can be different written tests. That was the rule set for the game, for the referee. And that rule has not been changed. That rule has not been changed. True? And that rule they have not objected to. Thirdly, we just now Supreme Court judgment. But hello, there is no change in the rule of game in this case.
Mr. Mitra, how long you will continue?
I'll try to finish today, Miller.
Today, very good.
I might not give me extra 5 minutes.
Yes.
That's not my client.
Take your time.
Really poor transmit. Last is the judgment of Supreme Court. Before reading a judgment, I shall submit from this judgment appear that it has been the practice of various institutions to have different written tests. And that was never said to be bad or wrong. Question is whether written test, second written test, in the facts of the particular case will be bad or good or bad. There is no rule of law.
Sorry.
There is no rule of law saying the written test cannot be comprised of different question papers for different zones. There is no rule of law. There is no statute saying so. No statute saying so. And there is no rule of law saying so. On the other hand, now see the Supreme Court judgment will not. It's the interim order. Anyway, this judgment, Mr. Bishuru has relied on that. Which is named out Oditi and others.
That I have referred now. Just
Yes.
WP Civil number 456 of 2025.
This is an
WP Civil number, yes. your judgment file ta dekhi bhai. Report decision file. Just a minute, sir. Just a minute. Yes, sir.
First, my lord, as I'm borrowing from my lord's observation, my lord, that there's been no violation of level playing grounds.
Yes.
There should no violation of level playing grounds, and the question papers are of same standard. This, having regard to these two facts, can it be said to be wrong by the court of which court, which is not a court of appeal? Paragraph 8 may not come to judgment. No, sorry, the ground, what the ground was that is See the first paragraph, paragraph 3. One is that holding of national eligibility examination in 2 shifts would give rise to arbitrariness. Why? As it does not extend...
Sir, straight away come to paragraph 10.
No, paragraph 3, can you see?
Paragraph?
3.
3, oh, I'm sorry. Yes.
One is that holding of national eligibility, etc., in 2 shifts would give rise to arbitrariness only, as it does not extend a level playing ground. Level playing ground, Milo already observed it, to all the candidates. And is much as 2 question papers can never be of the same standard. That is, for example, question also found a question paper same standard. Both the grounds are fulfilled here. Both the ground of level playing ground is not disrupted, and question paper of same standard. This is the reasoning why it cannot be done. And the process of normalization, last year, NET, PT examination held in 2 shifts, and the process of normalization was adopted in the scenario. So it was last year it was held by this institution in 2 shifts, and that was not held to be bad or anything. These are the facts. Now let us kindly see why it is wrong here. Paragraph 8. By Supreme Court, the interim order says, which is, I know nothing. This contention deserves to be rejected, as there is still enough time for the examining body to identify sufficient number of secure centers so as to hold the examination in 1 shift. By the time, this mistake, 2024, and the High Court order is that you must do it within a particular time. Then, in this case, why is there any time to hold the 2 examinations? There's a whole thing. That is the reason.
Sir, I beg to differ, sir. So far as the Aditi case is concerned, it deals with the level playing field and process of normalization. So far as the level playing field, I'm okay. It is okay. And what is the process of normalization? That must be backed by the rules, regulations. Must be backed by the at least by resolution taken by the how the process of normalization will be done.
Normalization is done.
How? Simply holding an examination in second shift.
No. Second shift. All the then marks have been considered together. And thereafter the list has been prepared. Therefore, I've read out that paragraph to your lordship. Yes. It was normalized. Paragraph, yes. Paragraph page 22. Results of both written examination held on 29/5/11 and 1st September 24 was published jointly by taking all the candidates in both the written examinations together on 99 and list of them paper. That was done. And then, in that case, a ground for that. See, why this is so? Paragraph 9. Paragraph 9. We find that total candidates who have applied this year was 2,42,750. Examination will be held all over the country and not in one state. We are not ready to accept that the entire country, considering the technical advancement we have achieved, examination body cannot find sufficient number of centers to hold the examination. And they're taking fees of 3,500, 2,500. Paragraph 9. This Now, the next thing is, in this judgment, I'm talking of this judgment. This judgment, this order was passed, interim order was passed, before the different tests were being held, not after. Not after participation in that test and then coming to court. This injunction was placed and no, it should not be done. There's a difference between a faith allowing a thing to be done and then come to court, and it's coming to court before that. That's not last one, paragraph 10. I'm reading out from judgment. Normalization may be applied. Last page. Normalization may be applied.
Paragraph number?
Paragraph 10, just above, end of the paragraph 10. Next page,
Yes.
Please turn the page. Normalization may be applied and adopted in exceptional circumstances, but not in a routine manner, year after year. It is an exceptional circumstance that is the case. So therefore, this can be allowed. And respect has been with immunity. The court will not see it as a court of appeal. Anything, no case of malafide against the commission. Malafide did it, favoritism, but do something. No case of malafide. And what did they gain? They gain nothing, but they want to nullify somebody who has participated in examination. This judgment of Supreme Court is a interim order amending in the facts of that case, confined to facts of that case. It doesn't lay down the rule of law. On the other hand, says, it can be done in exceptional circumstances. But even then, the writ petition on this petition should be dismissed, dismissed because of necessary facts, because of Supreme Court. The party will be affected and not before a lordship. Those are humble. So, I'm grateful to my Lord to be patient with me.
Who else will argue in support of Mr. Time is not. Only you will argue. Any other counsel? You will also argue.
Only cover the points which are not covered by my letters.
No. That I say, while adopting the argument of Mr. Mitro, Mr. Bhattacharya will argue, and you are also Mr. Bhattacharya. Chatterjee will argue.
Mr. Bhattacharya must be contributing something.
So no, I'm thinking whether we'll fix a 1 day or 2 days. That I intend to know. And Mr. Thor will reply.
Yes,
Reply, you will be confined only to the law points, sir.
in 5 law points they have what they are.
So tell me, I'll fix 2 date or 1 date.
I will take not more than 45.
45 minutes.
45 minutes.
5 points they have.
Very good, very good.
It is not the ICC.
Yes, Kulan, ask
May I Maila's leave to release from the matter? I may not appear it.
But I have to hand over that.
Things.
This is the original.
If Maila has got any query from me, please send for me. I shall come and. Otherwise, not my. It is a not kind deep to be. Well, you have different percentage.
Mr. Dhar, 10:30.
The fourth, there is a.
Second,
The only thing fourth, her marriage ceremony that on that and she was so that's the kind. So initially I would have said
no, it's all right.
That is
It is
sufficient
absolutely
ground.
genuine ground.
yes, yes.
For sufficient ground for extending the date. জন্ম মৃত্যু আর বিবাহ এইটা কারো হাতে নেই।
Or we skip to next week.
No, sir.
সেখানে তার হবে না তো
Then দেখো তুমি দেখো
13 জুলাই
Because
তুমি এই উইকে
আমরা তো
1 and 2 that primary is already fixed. That 32,000. আপনি তো ওখানে
হ্যাঁ, আমাকে এবার বলতে হবে।
হ্যাঁ এবার আপনার
First July না কবে আছে?
1st July 1 হ্যাঁ
ঠিক ঠিক
মানে 1st July that primary matter
মর্নিং এ করে দাও, আমার দুটো সময় তো
হ্যাঁ আমাদের
মর্নিং এ করে দাও।
মর্নিং কোনো অসুবিধা নেই। হ্যাঁ না even 1st July in morning no problem I say oh আচ্ছা কবে yes fine
You will finish on 30. হ্যাঁ, হ্যাঁ।
no first in the first half no difficulty but first from second half that primary that matter will continue
মিস্টার ভট্টাচার্য
30th
ফার্স্ট
মানে 30th
তোমরা এগুলো কেন একটু accommodated থাকো। 30th June।
on that day what Mr. Bhattacharya finishes অসুবিধা আছে কন্টিনিউ হ্যাঁ ফার্স্ট জুলাই হয়ে যাবে
first
বিকজ বলার কি আছে
হ্যাঁ
no ফার্স্ট জুলাই ফার্স্ট হাফ
এটা
ফার্স্ট জুলাই অলসো ফার্স্ট হাফ
ঠিক আছে লেগে ওটা দিন হয় ওটা দাও গো কল্যাণ বাবু দাও না
the original
একটু বলে দাও
if Lordship wants to check
give me the xerox
Check করে দিয়ে দিও।
Mr. Mitra,
Sir, may I, without saying, I had a great pleasure in arguing without saying, Milord, please accept my.
it is a learning for the code also, sir.
No, not. And please, Milord, if I may keep up the habit of telling the client, counsel, I have understood your point. What is the next point? Please keep up. This was done in old days.
Absolutely.
That will shorten the process.
Very good.
Sir, may I take measures kindly?
Prior to commencement of hearing, Mr. Dhor, learned senior advocate, appearing on behalf of the appearing on behalf of the commission, has filed 3 sets of question papers of the written examination as held on 29/5/2011. Why 3 sets, Mr. Dhor?
because earlier there were separate question papers in 2 separate sessions. So very point that level playing.
No. This question paper are of the written test.
This question paper of 2011 and that contains 2 sets and question paper of 2024 that contains 1 set.
Oh, I see. No, at the time of commencement of hearing, (29/5/2011) and 1/9/2024. Start. Let those photocopies of question papers be taken on record. Stop para. This court has heard Mr. Mitra, learned senior advocate, appearing on behalf of the writ petitioners in WPA in WPA 845 of 2025 in full. Stop. Let the matter be listed again. Let the instant matters. Let the instant matters be listed again on June 30 and June 30, 2025 and July 1, 2025. ঠিক বলছি তো? June 30, 2025 and July 1, 2025 with the mark 10:30 AM. Very good, sir. You take 45 minutes, 45 hours, but I will not allow you to argue on the same point. That very good, sir.
30th for reply.
30th June and 1st July. By 1st July, I am to complete.
Yes. So, Your Lordship, lies